We're going to go ahead and get started with our August 2025 Burr Morning Show. Welcome. We're so glad that all of you are here. We are delighted to be with you today. I'm Katy Willis, one of the partners in the Labor and Employment Practice Group, and joining me today is Scott Williams, a partner in the Labor and Employment Practice Group. A couple of housekeeping notes before we get started on the substance of our presentation. First of all, this presentation is being recorded. You will have access at a time after we're done to the recording. Should you like to hear it again, go back over a question or share it with other people at your work site. Also, we welcome questions. We feel like it's a very helpful tool to be able to answer those questions while we're live and while we're together. So if you have a question, please drop it in the Q&A box at the bottom of your screen. If for some reason you can't access that, place it in the chat box. We're going to monitor it and look for any questions that you might have and try to get to as many of them as possible, and we encourage those. Scott's going to get more into it, but our topic today is an OSHA update. That's something that affects, I would think, almost all of you here today, and we do have some things to share, especially with a Trump 2.0 administration. Nothing earth-shattering, but a lot of good reminders, I think, about what you all need to be doing as far as preparedness goes. So I'll turn it over to Scott to begin.
All right. Well, thanks, Katy. I'm looking at our attendees and see some familiar names. It looks like our audience includes various professionals from a variety of industries. But whether you work in safety, human resources, operations, or even in-house legal counsel, you likely have some responsibility for safety and health issues in your workplace. So understanding that everyone here has some responsibility for workplace safety, we want to start with what we imagine as a refresher on some of the OSHA basics. You can go to the next slide. So the OSHA Act requires employers to provide a workplace free from recognized hazards to safety and health. OSHA really has two main functions. One, setting uniform health and safety standards, and two, conducting inspections to ensure employers are complying with OSHA standards. I think a third function is whistleblower cases, and we've seen an increase of those lately. But if employees make a safety complaint of any kind or report an on-the-job injury or illness, and an employer takes an adverse action against that employee based on that protected conduct, they can file a whistleblower claim against their employer. OSHA is responsible for investigating and enforcing OSHA's whistleblower statute. But there is also certain avenues left to states. The OSHA Act actually encourages states to develop and operate their own safety and health programs. States with OSHA-approved job safety and health programs like southeastern states like Tennessee, Kentucky, and the Carolinas must set standards that are at least as effective as the equivalent federal standard. As you all know, states also have workers' compensation statutes that require employers to provide benefits to employees that are injured on the job. And while state law generally provides that workers' comp relief is the exclusive remedy against employers for workplace injuries, co-employees may be subject to tort liability for willful conduct that causes injury or death in the workplace. And we typically see that when we have coworkers or supervisors remove a safety guard, for instance, which causes an employee injury. Even though the employee's exclusive remedy is workers' compensation benefits against the employer, they can sue that co-employee individually for the removal of the safety device.
And I'll add to that, Scott, with the retaliation piece, since we are seeing such an uptick. It's important for those on the call who may not be familiar with that process. It's a separate investigator from your average, ordinary area OSHA office, so it's different investigators. We have found some that have been very run-of-the-mill, very standard. They want your position statement, they review it, they may ask for a few documents, and they move on. Like any other federal agency, though, we've also encountered some investigators that are a bit more aggressive in their investigatory efforts, and they are more, they are prying for answers. And in fact, we encountered one within the past year and a half that was, we thought basically they were representing the employee, because they kept asking, why didn't you do this? Why haven't you done that? I know we have both safety and human resources professionals with us today. And I would say, even though that this OSHA 11C retaliation protection is out there, obviously that doesn't mean that you can't discipline or counsel or even potentially terminate someone who's raised a safety or health complaint. Of course, like any retaliation claim, timing is really important. If there's bad timing, there's more likely going to be a finding that there was some retaliatory motive. But the best medicine in this case is prevention, and the prevention in this case is good documentation. Meaning, if you've got an employee with poor attendance who all of a sudden pops up with a safety and health complaint, if you as an employer have been documenting that employee's poor attendance up to that point, it makes it a very defensible retaliation claim to show that this was an ongoing problem. So I would just encourage you all, especially those who are not safety, to keep in mind that, yes, you have to be careful when making these employment decisions surrounding someone who has recently brought up a safety or health complaint, but good documentation and consistency is key in defending those. And I think we can go to the next slide.
All right. So there's three main elements of OSHA compliance: the general duty clause, safety regulations, and emphasis programs. Under the general duty clause, employers have an obligation to protect workers from recognized hazards, even if there's no standard regulating or addressing the hazard. The most recent well-known example would be the COVID-19 pandemic. OSHA did not have a specific standard addressing infectious diseases in the workplace. That being said, every employer on this call recognized the spread of COVID-19 in the workplace as a safety and health hazard. So if your company did not follow CDC guidelines and best practices, even though OSHA did not have a standard addressing infectious diseases like COVID-19, OSHA could still cite you under the general duty clause. Some other common examples are heat stress illness and workplace violence. The second major element of compliance is, of course, the safety regulations themselves. You've got specific standards that OSHA promulgates that regulates various types of work environments and instructs employers how to comply. A good example is the machine guarding standard. It tells you exactly what needs to be done and how to do it. Unlike specific standards, performance standards don't tell you how to comply. Instead, these standards are performance-based. For example, if you look at the respiratory protection standard, OSHA will tell you that you need a written respiratory protection program. However, it does not tell you how to set up the program. It does provide some guidelines and specify some requirements, but in general, it leaves the how part of the equation up to you. And then finally, the third element of compliance are these emphasis programs. These programs are developed on a national, regional, or local basis to focus outreach efforts and inspections on specific hazards in a workplace and or specific industries. And we're gonna talk about at least one of those emphasis programs later today.
I think we're ready for the next slide. Okay, let's talk about general industry, not specifying on construction or maritime, but just general industry. What were the top 5 citations for last year, for fiscal year 2024? Because I think this can be instructive to all of you. It is very helpful to know what OSHA is looking for. The first one is hazard communication, or HAZCOM. And this is basically the standard that says if you have chemicals, if you have mixtures in your workplace, they've got to be specifically labeled as such. They've got to be kept and maintained and stored in a certain way. And you have to have MSDSs or material safety data sheets that are available to employees to look at, to see what is in these various chemicals or whatnot in the workplace. So HAZCOM is one. There's also a training element associated with that. And I'll come back to training because that's key to a lot of this. Respiratory protection, as Scott said, is more of a performance standard without saying you have to have this type of respiratory protection in this type of industry or at this type of work site, but it does contain certain standards about when respiratory protection must be provided, what kind of monitoring should be done, and gives guidelines as to that. Number 3, I'm surprised this isn't a bigger one because we see it so often, Scott and I do, which is lockout, tagout, the control of hazardous energy, whether it be, hydraulic, pneumatic, whatnot. And one of the biggest issues that we continue to see in OSHA inspections are cleaning of machinery, and whether you've got a lockout or lockout and tag out when machine parts are cleaned. And OSHA typically takes the position, yes, that is an activity that requires lockout and tag out. Training is another big piece of this particular standard, because you've got to make sure that people are appropriately trained. For people who are designated, who are assigned locks, who have lockout, tagout responsibilities versus affected employees, they've got a separate type of training. Another miss that we see on employers' part is failing to do the annual review and certification under lockout, tagout. And that's kind of a gotcha that OSHA will have. It's more of a paperwork violation, but they still very much consider it a serious violation. You're probably not going to get an other than serious because OSHA considers lockout, tagout to be so crucial to the overall health and safety of the workplace. Powered industrial trucks, number 4 on this list, is a fancy word for forklifts and tuggers. One of the top downfalls we see in inspections are failure to maintain those forklifts or tuggers. Seat belts are ripped out. But another big thing that we see is failure to inspect, whether it's at shift change or on a daily or bi-weekly basis, to inspect the forklifts for operational safety. Training, again, is an essential element of this one because OSHA will be looking for, there was an incident. Somebody ran into a rack. Somebody ran into a wall. Somebody damaged product. What did you do to retrain them? Because they have the expectation that if an incident like that happens, that retraining occur. And a lot of times we don't always see that happening. And, this is one of the tricky pieces of OSHA, of defending an OSHA citation, is what if that somebody got hurt while they, backed into that wall or backed into that rack? Most employers, just having empathy and sympathy, say, well, we don't want to write somebody up that's already hurt or that, is out on workers' comp leave. And you've really got to seriously look at, did they violate a standard? Did they disregard a safety rule that they've been trained on or instructed on? And that later becomes important if you have a citation, because one of the defenses that you can argue is employee misconduct. Meaning we had a rule, we published the rule, we went over it in training, they signed off on a sheet, or we went over it in start of shift meetings that they attended, and they violated the rule. And by the way, we have written up or counseled people who have violated this rule. So that's just a good reminder there that it's really important to be consistent when people are violating safety rules, to address appropriately and consistently with whatever your disciplinary policy be it progressive or otherwise. The last one on this list for 2024 is machine guarding. Again, this is a big one. This is a big one we see, particularly in the automotive industry. Can somebody reach into a machine? And OSHA really doesn't care if they shouldn't have, basically, if they shouldn't have done it, or if common sense says don't reach in there and manipulate that part or get things moving along. The employer has the responsibility to guard machines in such a way to avoid pinch points, to avoid things like amputations, even if they are something like a fingertip amputation. And this is also a good reminder here that if you do have something like an amputation that requires hospitalization, that you've got a certain amount of time to notify OSHA. That's 24 hours. If God forbid it would be a fatality, it's 8 hours from the time you learn of that. So it's important that you keep in mind those notification obligations, because OSHA can cite you separately for failure to timely notify, on top of whatever substantive violation that they might find.
Yeah, and the only thing I'll add, and Katie already mentioned, is this list does not include citations issued under OSHA's construction standards. It's limited to general industry, but to the extent we do have friends from the construction industry joining us this morning, their top 5 list from fiscal year 2024 is the same list that appears every year. Fall protection, ladders, fall protection training, scaffolding, and personal protective equipment. But this list is general industry only. And as Katie said, it is somewhat surprising that OSHA's lockout tagout standard continues to hold the 3rd spot, but there was a 24% increase in the total number of lockout tagout citations over last year. And this list is again just the number of citations, not the penalty amounts. If you turn this list into the top 5 penalty amounts issued, lockout tagout actually rises to number 1. All right, so if OSHA inspects your facility and determines that you violated a standard, an OSHA citation generally results in a civil monetary penalty. These penalties have increased each year since 2015, and we certainly expect another increase in January 2026. Currently, the civil penalties include a maximum penalty of $16,131 per citation for other than serious and serious violations. An other than serious violation is one in which OSHA has determined that the hazard will not result in a substantial injury or death. Serious, on the other hand, is one where OSHA has determined that the hazard most likely will result in serious injury or death. Then we have a maximum penalty of $161,323 per citation for repeat and willful violations. A repeat violation means that you've been cited for the same or substantially similar violation in the last 5 years. And a willful violation means that the employer has shown a heightened disregard for employee safety. And then finally, you have failure to abate citations, which carry a maximum penalty of $16,131 per day from the deadline that you should have abated the hazard to when you finally abate the hazard. In addition to civil liability, it's very important to understand that an employer may be subject to criminal liability under certain circumstances. Specifically, if OSHA finds that a willful violation of an OSHA standard caused a fatality, OSHA can refer the matter to the Department of Justice for criminal prosecution. The DOJ could then seek both monetary fines and imprisonment of company officials. It's also important to note that you can be subject to criminal prosecution for lying to OSHA during inspection. And the next slide is actually demonstrates that criminal prosecution is a reality.
That's right. Just recently, the 7th Circuit Court of Appeals upheld a decision to affirm criminal convictions against the Vice President of Operations and the Safety Superintendent arising from a 2017 explosion at a corn mill in Wisconsin. Okay, and I will say, just from a legal perspective, Scott, the 7th Circuit is not the most liberal circuit. They're not the most conservative, but they're certainly not the most liberal circuit court of appeals in the U.S. So I think this was a really significant decision. But you note here, it wasn't just, and I think this is very important for everybody on this call, that it wasn't just the safety person that was on the hook here. The VP of Operations took the fall for better or for worse too. So I think it's very important. Oh, I don't wear that hat. Well, that's somebody else's responsibility. If you have any sort of oversight into the safety function, and I know a lot of people with HR hats on do oversee EH&S as well, and a lot of companies, particularly smaller ones, beware here. In particular, in this particular case with the corn mill, the mill workers would falsify air pollution readings and sanitation logs because their boss told them to. So there were false records. And obviously this falsification of records led to conditions that OSHA, at least in OSHA's view, that contributed to this explosion. The VP of operation was the signatory, the person that signed off on compliance certifications that omitted the improper recording practices. So I think it's a great reminder in the eyes of both OSHA and the DOJ that you are responsible for what you sign off on. I think it's also a very good reminder to make sure you're hiring and screening the right people for this type of responsibility. Obviously, you have a lot of things going on every day and probably a lot of hats that you wear. So you probably can't go through and verify every single piece of information is correct, but you've got to be able to rely upon the people that report to you and that you work with, particularly in the safety space and the safety function. Significantly here, both of these managers were sentenced to 24 months in prison. So it wasn't just a slap on the wrist. It wasn't just a fine to the company, but it was actual prison time. And I think this is a very sobering decision, obviously, because the explosion did result in fatalities, and that's the most serious consequence. But here it resulted in additional consequences for the people in charge.
Yeah, and this slide is something that you should use if you're not getting adequate buy-in on safety from your executives. The fact that they could be subject to criminal prosecution and imprisonment for safety violations will go a long way in making sure that you get the resources you need to make your workplace as safe as possible. We can go to the next slide. Now that we've given you a refresher on the basics, we want to look at some recent OSHA developments. And that really starts with understanding where we are in the current state of OSHA under the second Trump administration. As you know, OSHA is a division of the U.S. Department of Labor. And while President Trump somewhat shockingly nominated former Oregon Congresswoman Loy Chavez DeRemer, she was confirmed as a Secretary of Labor. And while she is a Republican, she has very strong pro-union ties. She's a daughter of a Teamsters, and the current Teamsters president publicly supported her nomination. So given Chavez DeRemer's pro-union background, forecasting her potential impact on OSHA is somewhat difficult. But reporting to the Secretary of Labor is the OSHA chief. This is another position that is nominated by the president and must be confirmed by the Senate. If you recall, OSHA actually operated without a confirmed OSHA chief for the entirety of the first Trump administration, which had never happened before. This time around, in February of this year, President Trump nominated David Keeling, who is a former safety director at UPS and Amazon, to take the lead position at OSHA. He has not yet been confirmed, but Mr. Keeling's background in corporate safety management would at least seem to indicate that he is employer friendly. If you look at OSHA's budget in the last 3 fiscal years, OSHA's budget actually remained unchanged from fiscal year 2023 and 2024. In fact, after factoring in inflation, it was essentially a budget cut. But President Biden did get an increase of roughly $23 million for fiscal year 2025, but that increase is short-lived as the fiscal year ends next month on September 30th.
What are the priorities of the second Trump administration? There has been a heavy focus that OSHA has announced, and I think it's actually playing into actual practicality or practice with compliance assistance. With different administrations, you see more of a investigatory, almost prosecutorial type emphasis of we're looking for the violations versus compliance assistance. We want to help you comply. Multiple area offices, even under, I will say, even under President Biden's administration, have added compliance individuals to their team and to their staff. We would encourage you to utilize those people because they are there to answer questions. Now, they're not going to give you the answer, are you doing this right or wrong? But if you get a new piece of equipment or you're unsure how to handle a situation, you can certainly call them and they'll probably give more generalized than specific advice, but they are there to help. They're not there to write up citations. They're not there to inspect your facility or your plant, but they can be of some assistance. We are unlikely to see a push to increase the budget or backfill enforcement personnel at OSHA, especially considering DOGE and all the impact and the fallout from that. So we don't anticipate that. I don't want anybody to take that to mean that we're going to have fewer inspections, because keep in mind that OSHA is obligated to come out and inspect fatalities. More likely than not, they're coming out to inspect something like an amputation or an inpatient hospitalization case. We may see OSHA using more of what we like to call the phone and fax method, where they email or fax you a letter saying this complaint or this concern has been reported in the workplace. Here are the specific elements of that complaint. Please respond to the complaint within 7 days and tell us what you, as an employer, have done to remedy or investigate and remedy the situation. And you, as the employer, have the opportunity to respond. We often assist employers with these responses just to make sure, number one, that they're accurate and truthful. Number two, that they're comprehensive. But number three, that they don't invite OSHA to come on site, because if OSHA is not satisfied with that response, or they find what they believe to be a deficiency or something that they feel that they need to look into further, they then may show up at your work site to conduct an on-site investigation. So we may see increased use of that. You do need to take it seriously, because they still can be used as a basis for an inspection or a potential basis for a citation. Going forward in the Trump administration and the second administration, we do believe there may be a scale back of press releases shaming employers. I'm sure you've seen them before. We could put up multiple ones on the screen if we needed to. OSHA cites Georgia plant for, $700 million for such and such violation. OSHA cites oil refinery, this amount, and they put out these press releases as a matter, I guess, in their minds, of public service, but also to employer beware, shame into compliance. We're not sure we're going to see as much of that. We may see some rollback on certain enforcement policies and practices, but don't be fooled. The lockout tag-out standard isn't going anywhere. The machine guarding standard isn't going anywhere. Basically, a lot of the standards aren't going anywhere, but we may see less push for things like rules around heat, or enforcement programs around, or rulemaking around something like heat. We may see some of that. We may see a reduction in the actual number of emphasis programs. And I think it's important to emphasize here, as we're talking about emphasis programs, that an emphasis program, as we're about to look at shortly, it can be national, meaning it impacts anybody anywhere. And if you've got sites in multiple states, that would impact you everywhere. It could be regional, meaning the OSHA region in which you sit, or your work site, your company, or your work sites are located. It can even be state-based if you've got a state-based program. So you could be subject to multiple emphasis programs, not all coming out of the same OSHA office.
Yeah, and it's difficult to predict which Biden rules will be rolled back, but some that come to mind, electronic record keeping, the rule that started under the Obama administration that certain employers with a certain number of employees have to electronically submit their injury and illness data to OSHA on an annual basis. That was rescinded under Trump's first administration. It was brought back and revised under the Biden administration. That seems to be one that would be clearly rescinded under Trump 2.0. Another one is, OSHA's expanded application of its instance by instance citation policy. Prior to the Biden administration, if you had 10 presses on your manufacturing floor and you did not have a lockout tagout procedure for any of them, because the machines were similar in nature, you would get one lockout tagout citation. Under this expanded application of instance by instance, we've seen OSHA during the Biden administration issue 10 separate citations, one for each machine. So hopefully that's something that gets rescinded, and certainly the aggressive use of willful and repeat citations during the Biden administration. We just hope that OSHA will no longer be exploring creative ways to enlarge civil penalties. Let's go to the next slide, and this is what Katie was talking about. Unfortunately, in this instance, we did not, the Trump administration did not decline to renew a national emphasis program. In fact, it did renew it on June 26. And this national emphasis program is on amputations. It allows OSHA to conduct an inspection at certain employers that have equipment or machinery that could potentially cause amputations. During this programmed inspection, OSHA focuses on how our activities are during setup of the machinery, maintenance of the machinery while in operation, and then certain maintenance activities or even cleanup. Importantly, OSHA updated the list of industry codes subject to this national emphasis program. While there was a significant reduction in industries, there were new industries added to the list as well. So you want to pull that list and find out if your workplace is subject to this national emphasis program, because if your workplace is a part of an industry subject to this national emphasis program, that means OSHA can show up at any time to conduct this programmed inspection. It also means that if OSHA's on site at your workplace for an unrelated, unprogrammed inspection, maybe you had an employee complaint, or you had to call in or self-report an inpatient hospitalization, then OSHA can expand that unprogrammed inspection to cover the national emphasis program here as well. The only way to be deleted from the programmed inspection list is if your workplace had an inspection under this program in the previous 24 months and did not report an amputation during that period.
Okay, this is an interesting one. In July of this year, OSHA issued a notice of proposed rulemaking to narrow the application of the general duty clause to inherently risky activities that are integral to certain occupations. Okay, so let's keep in mind, let's briefly review what the general duty clause is. I like to say that the general duty clause is the clause that OSHA applies when they don't have a specific standard. They've used it before for heat. They've used it before for COVID type, not adhering to CDC type regulations. They've used it basically to say that there was a hazard and that you did not take, as an employer, did not take appropriate steps to protect the health and safety of your employees. Now, there's certain defenses to it, one of which being, hey, there's a more specific standard that could apply, or we took every possible step and what you were proposing is not even feasible, whether it be financially, from an engineering perspective, even from a creating an additional safety risk perspective. But general duty clause citations carry the same monetary penalties as what Scott went over earlier, but they can be very difficult to defend just because you're dealing with a more generalized nature, and OSHA may take the position, this is what you should have done, and you may be in a position saying we can't do that. But in any event, going back to what's happened recently with the general duty clause, As it stands now, the general duty clause does not authorize OSHA to cite employers for hazards that are inseparable from the core nature of the activities of an occupation. So some of these sectors of industry that may be impacted in this proposed rulemaking, it's not done yet, and it would have to go through several steps, would be live entertainment, performing arts, animal handling, professional and extreme sports, monster trucks, I don't know, and high-risk recreation. This is especially interesting because I don't know if you've all followed, this started really about almost 15 years ago, maybe even longer, when a whale at SeaWorld attacked its trainer and killed the trainer. And there have been several other instances like that, even more in more recent times than 2009, 2010 timeframe. But what OSHA is proposing is that this general duty clause may be limited in those type industries only. Probably not going to affect a lot of people on this call, but it may be an interesting insight into how frequently the Trump administration 2.0 OSHA is going to utilize the general duty clause in just overall industry, not these particularized areas. Still in these areas, there would be the expectation that they would make reasonable efforts to control hazards that don't alter the nature of having a show at SeaWorld, having a monster truck rally, whatever it might be. And because this is proposed rulemaking, it goes through the Federal Register. It's open for public comments on the standard, and they have to be received no later than next week. So if you have any interest in that, now's the time to take a look into it, because that's when public comments are going to close, and then the rulemaking process will proceed.
All right. So on July 14th, employers got some relief in that OSHA slashed penalties for small employers and quick fixers. If you have 25 or less employees, you are eligible for a 70% penalty reduction on OSHA citations. Everyone on this call would be eligible for what you call a quick fix reduction. This means that if OSHA identifies a hazard during an inspection and the employer corrects or abates that hazard while the inspection is ongoing, you would be eligible for a 15% penalty reduction. And then finally, OSHA codified a clean history credit that allows employers to be eligible for a 20% reduction if they've never been inspected by OSHA or a state plan, good luck, or you've been inspected in the past 5 years and had no serious, willful, repeat, or failure to abate violations. So this is certainly something to remember. We see it all the time in terms of quick fixes, and it's something that we encourage employers to do when we're on site involved in an OSHA inspection. If there is an obvious hazard, we need to fix it while OSHA is still there. And while this was an argument before July 14th, now it is a certainty almost that if you do it while OSHA is still there, fix the hazard, you'll get a 15% penalty reduction.
Well, that brings us, I know, Scott, you're going to close this. If anybody has any questions, though, we're happy to entertain them now. And Scott, I'll turn it over to you to close us out. But I certainly appreciate your being here and participating.
Yeah, we tried to monitor the Q&A as we went alternated slides and did not see any questions. Certainly, if you have questions and don't want to ask it in this setting, you can reach out to Katie or myself with any questions. If you talk to your safety team or management team about this presentation and they have questions, please feel free to reach out. We're happy to answer them. But as Katie said, Friday before a holiday, we know that everyone has more important things to do, and we really appreciate you all participating and attending this Burr Morning Show.
Actually, we did just, we got to thank you in the Q&A. We appreciate that. I wanted to make sure before we closed out, we didn't cut anybody off. Thank you all again. We really appreciate it.